The House Civil Law and Procedure Committee considered a whole package of bills today, all aimed at addressing frivolous litigation in Louisiana and ultimately to improve Louisiana's legal climate. We're very pleased that the House took action on these bills. Most importantly, the House acted today to advance House Bill 917, which will effectively eliminate Louisiana's jury trial threshold. Currently, if you're involved in a civil lawsuit in Louisiana and the case is worth less than $50,000, citizens do not have the right to request a trial before a jury of their peers. We think that's wrong, and the House Civil Law and Procedure Committee today voted in favor of that position. They voted to eliminate Louisiana's civil jury trial threshold to ensure that citizens involved in litigation in Louisiana have the right to access a jury trial. We support what they did. We're very thankful to the committee for taking the appropriate action, and we look forward to continuing to have this discussion as the bill advances to the House floor.
The Civil Law Committee just concluded its hearing, and they passed out HB 917, which is a bill by Representative Garofalo to lower the jury trial threshold in the state of Louisiana. Right now in the state of Louisiana, you have to be sued for $50,000 in order to have a jury of your peers hear your case. It's not fair, it's not right, and it's completely out of whack with the rest of the country. 49 other states have a low threshold to get in there. So if you get sued in another state and you want a jury, it's your right. In Louisiana, we have an arbitrary bar of $50,000, which prohibits citizens from getting their right to a jury. We want to take that bar away. We want every citizen to have fair access to the courts. I think if you're a citizen and you get sued, that's where you feel it. If you get sued, you want to be able to have the right to say, you know what, I'd prefer a jury on this one. And it's a discretionary right. It's completely optional. And other states have viewed this as a no-brainer, and it's time for us to view it as a no-brainer. What happens is if you keep the public out of the courtrooms, then it's just the select few attorneys and the select few judges who decide everything, and we think the public needs to have a seat at the table. And this will allow them to finally go into the courtrooms. You know, the legislative branch, there's a lot of participation in hearings and in floor debates, and on the internet you can live stream, you can do all of that. In the judiciary, they're kept out of the process, and it's time to insert the public into that process. The committee today basically served as a jury, and they heard a lot of conflicting evidence and data and all that stuff, and I just appreciate them taking the time. It's a strong vote, but we've got a long ways to go from here. We know it's going to be a big battle on the House floor. We know we've got our work cut out ahead of us, but we're excited for the challenge, and we think every citizen deserves this right.
The House committee also voted today in favor of House Bill 482, which will establish proper venue in certain cases in Louisiana. Unfortunately, sometimes we see in Louisiana some members of the plaintiff's bar that will take cases to favorable, what are perceived to be favorable jurisdictions throughout Louisiana. This is often referred to as venue shopping. Unfortunately, that puts a tremendous strain on judicial resources in these communities that are viewed as being favorable to plaintiffs, and so House Bill 482 will establish proper venue in certain civil litigation cases and effectively put it into jury shopping or venue shopping in Louisiana. Again, we're very appreciative to the House Civil Law and Procedure Committee for taking action. The bills that were moved today, the lawsuit reform bills that were moved out of committee today, will go a long way toward improving Louisiana's legal climate and making it easier for small businesses to operate in our state and for the workers and families who depend on them.
We just officially passed House Bill 482, which is going to help impact a lot of small businesses across the state that actually will have their hearings or their jury trials within their districts instead of being maybe spun about in different parishes in Louisiana.
I'm here today in support of the bill on behalf of the Coalition for Common Sense. As Representative Shadowin mentioned, a bill of this type has been up before this committee at least 2 times before. The aim of the current proposed bill, which would add 78.1 to the Code of Civil Procedure for the venue provisions, would be to apply to cases of latent disease. And what the bill would do would be to provide that venue would be appropriate in the parish or parishes where the exposure to the toxic substance occurred, rather than in the parishes where the defendants are domiciled. And so what the part that is eliminated is the location of the defendant's domicile. The reason for that change is to avoid, I'd like to give the committee 2 examples, situations like these, and I'll give one example of a case that involves an out-of-state plaintiff and one with an in-state plaintiff. And what we see happening over and over again in these asbestos cases and other hazardous substance cases is that suits are filed by a plaintiff, for example, the Stephen Slappy case, which is in Civil District Court for the Parish of Orleans. I'm sorry, it's in Baton Rouge in 19th JDC. The plaintiff, Mr. Slappy, sued 45 defendants. He's a resident of the state of Georgia. And in his 39-year exposure history, he worked almost exclusively at one plant in Georgia. However, he sued the 45 defendants in Louisiana, filing suit in Baton Rouge, because 4 out of the 45 defendants had principal places of business in Baton Rouge. But once the suit was explored a bit, we came to learn that there was actually only 4 weeks of exposure out of the 39 years in Louisiana. The 4 weeks of alleged exposure were in 1960. Nonetheless, though, venue was appropriate in Baton Rouge based on those domiciles, and forum nonconvenience motions were denied. That case was brought by a Texas firm filing for a Georgia plaintiff here in Louisiana. As an example of a Louisiana case for a Louisiana plaintiff, the Jeffrey Melford case was filed in Civil District Court. The Melfords are lifelong residents of Jefferson Parish. They didn't file suit in Jefferson Parish, so they filed in Orleans because one defendant was domiciled in Orleans Parish, even though all of the exposure occurred elsewhere. The bill is aimed at narrowing venue in the cases of latent disease situations to those parishes where the alleged wrongs have occurred, where the witnesses are, where the exposure took place, rather than being able to hook into another venue just based on the domicile of perhaps 1 or 2 out of as many as 60 or more defendants. The bill, as Representative Shadowan mentioned, is tailored at this time to address some of the concerns that were raised with past bills of its type. In particular, in the past, there was some concern that the transfer provision of this bill that would allow a court to transfer a case to a parish of exposure where more witnesses reside was mandatory, using the word shall. But now in the current form of the bill, the language has been changed to permissive and uses the word may. So the judge may transfer the case if he sees appropriate. Also, there's been a provision inserted into the bill that would address the situation of when the plaintiff files suit in his own domicile. As long as the plaintiff's own domicile is an otherwise valid venue, the case cannot be transferred away from the plaintiff's domicile. And finally, a third opposition that has come up over time is that the word substantial used to be included in the bill. It had to be a parish of substantial exposure. The word substantial has been removed to eliminate the concerns that interpretation would be needed with that would spawn additional litigation. So the bill on its face is straightforward and intended to address situations of venue shopping which occur day in and day out in the asbestos litigation, as well as silica and benzene, both by in-state plaintiffs and by plaintiffs that come into Louisiana from out of state. The venue provision is really no different than provisions of our neighbors in Texas and Mississippi. Those states have narrowed their venue provisions over time, as well as have incorporated other forms of tort reform. So for all of those reasons, I am here in support of House Bill 482 and 483, which would narrow venue in cases of latent disease.
My name is Mike Carter, and I'm the president of a business in Monroe, a family business, Monroe Rubber and Gasket Company. And I've been here on a few occasions and still able to come back today by invitation to update you on my situation as one of many small businesses in Louisiana that has been inundated with frivolous lawsuits, asbestos lawsuits in my case. First and foremost, let me make it very clear that I'm very compassionate about those people that have some asbestos-related disease based on the way this happened. And yes, there are those out there that should be responsible for taking care of this and paying these claims, and those are the people that should be targeted to do this, not my company. I've never manufactured asbestos. I'm simply a small business that bought a product from a manufacturer and resold it to an end user who asked for it by name. But as we speak today, I've received 109 different lawsuits with upwards of 3,000 plaintiffs. And as of today's date, it's cost me $2.3 million to defend those. I've not been in a courtroom yet, and I've managed to stay off probably about 80% of those cases, but it's not without a lot of money. And I'm able to be here today and be a voice for some of the businesses that can't, or they're not around anymore. And with our business climate here in Louisiana, me having to deal with this kind of stuff is ludicrous. I just cannot believe that this kind of money has been spent defending lawsuits, and in some cases in parishes that I've never even done business. That's why I say frivolous. Oh yeah, I get out on them summary judgment, or they'll drop the case, but it's not without having to defend it and spend a lot of money. So this House Bill 482 is not going to really help me a lot. It's going to help a lot of companies in Louisiana down the road, for sure, because it will keep them in their parish where at least the incident occurred, and it doesn't allow suits to come from all over. In the very beginning, I had them come in from Orleans Parish, from probably 5 or 6, 7, 8 different parishes in Louisiana, which I have about a 150-mile a perimeter that I do business in, and it's not all over the state, but I just happen to be thrown in there because, well, that guy, yeah, he had something to do with asbestos, so we'll put his name in there too. And I can't go back to these people and do anything. I mean, it's just, I'd love to go back and sue some of these people that are wasting my time. I mean, I'm up here trying to defend something that this is not what I do best. What I do best is at home in Monroe, and I've got a business there and one in Arkansas. And I can tell you, as of today's date, if I had anything else to open, or I was going to expand it at some point in time, it wouldn't be in Louisiana. I mean, guys, our climate is horrible here because we cannot get support. We come here, I come here, I ask for support from you guys and ladies, and I leave here, I never hear from anybody, I never hear anything, nobody ever calls to continue the conversation, and I've got a very limited time here, and I know that. But this House bill will help some people, and as long as I still have a little insurance money left to spend, I'm going to defend this as far as I can go. But when I get to the point, I have about a $3 million cap, and when I get to that and it starts coming out of my pocket, my pockets aren't that deep. I'll go away. Mm-hmm. And I've come here and I've told all of you this so many times. I've done it here. I've done it in Washington, and I've tried to meet with anybody that would hear me. But as of today's date, I have got nothing done, and I am slowly reaching my cap where maybe I won't be here anymore. But it won't be that I go down without trying to fight for what I feel like small business in Louisiana should be. They say we're the backbone. Well, you know what? Our backbones are about to break because we do not get any support, I feel like, personally, coming from me, that anybody has really stuck their neck out to try to make a difference in this. I just don't. And yeah, I do come here, and a lot of you might be tired of hearing my story, but as long as I can come here, I'm going to come here, and I'm going to talk about things I'm compassionate about. And I say go after those people that are responsible, the big companies, the manufacturers. Yeah, go get them. They probably knew a lot of things that were going on and continued to sell things that they shouldn't have sold. But I'm not part of that manufacturing process. But all of those big guys have gone bankrupt, filed bankruptcy, done something. So I just happened to be the next one in line that had a product, asbestos, in my description. Anything I had was encapsulated, and